All right, guys, we're going to go. And ladies, I want to talk to you about the first attachment that I sent you, and I'd like to take this opportunity, I hope you'll find it helpful, to give you a quick walk through the Broward Property Appraiser's website. There's a wealth of information there, and simply Google Broward Property Appraiser, and I thought, maybe not. Let's try that again. It says I'm going to Google UK. Bing suggestion, Debbie Orszewski. I don't think we need to search that.
Debbie.
You just type it in bcpa.net.
Oh, that's not sure.
Yeah.
So sweet.
Forgetting how to get there, which I'm sure this page can't be displayed.
Enter. It ends up.
The internet's not working. It's not you. It's not you.
It's not coming up. Well, I got Google and I got AOL.
No,
The internet. The internet.
Google always comes up, but the internet doesn't work out.
Yeah, but it's just not gonna connect. Is that what you're saying?
Yeah.
Maybe internet.
Okay.
Maybe it's
Is there a password to sign on? Does anybody know?
You're in.
No, you're in.
We're in. It's just not
Try
working.
using Firefox instead.
Access denied.
Or Chrome.
How about somebody come up here and try? If we can get the page up, I want to walk you through it. If we can't, we won't. I got another way I can get it up there, but I wanted to.
There you go.
Woo! Yeah, and I clicked on that and it just didn't come up.
I think their website's down.
Probably.
Their server's down. All right. Well, that means
I get it.
I also. Okay, thanks. That means I also can't display it from the. Because I was thinking I could go into my email and display it from the attachment I sent you, but not going to happen. So let me kill this to quit the distraction.
You go to Miami-Dade's.
The website.
Yeah, but the one I want to show you is not going to be there. All right. I'd like you to look, please, at the first attachment I sent you, which is the Broward Property Appraiser's website. I want to commend this website to you as a source of incredible information, and you go to the Property Appraiser's website and you hit a tab called Property Search. And when you hit Property Search, it'll ask you, how do you want to search? By owner name, by street address, by legal description, by tax folio number. There are all kinds of ways to search. Now, the piece of property that I want to show you is the one that I sent you the sheet on. And I've got a bunch of deeds from that same piece of property, and I'd like to walk you through this. So simply, and there's tons of stuff here that I haven't talked about. You can see maps, you can see aerials, you can see sketches of the property, of the improvements. It's a wealth of information. What we did here in this sheet is on site address, top tab, I typed in 300 Northeast 3rd Avenue, Fort Lauderdale. And you get this page. So, this is a piece of property that I happen to know well. I want to walk you through what information you can see here. And I want to show you all the deeds that it shows us, because we're going to talk about deeds, obviously. Okay. On the upper right, ID number, that's the tax folio number. That's the number that's on the tax bill for this piece of property. And you can search that way. And sales contracts ask you for the tax folio number. Deeds have to have it on there. That's it. The site address by street address, It tells you who the property owner is. It tells you the mailing address of that property owner. So, and an abbreviated legal description, which, as I've told you, is kind of a bass-backwards way of getting illegal. It gets you in the ballpark, but you want to get it somewhere else. Now, so, you see a piece of property, you want to find out who the owner is, here you go. Type in the street address. It'll tell you the owner's name. It'll tell you the mailing address where the owner's tax bill is mailed. It'll give you a short legal description. And then it's going to tell you about the piece of property. Next section are the assessed values. You remember we talked about your taxes are your assessed value times the millage rate equals the tax bill. So, for the year 2014, this tax year, this tax bill that came out a month ago, 2 weeks ago, the land on this property was assessed at $213,960. The building was assessed at $210,000 for a total just value, market value of $423,000. This assessed value, that's after you have your exemptions and stuff, but this is the assessed value, meaning what are you going to pay taxes based on, is the same $423,000. This year's tax bill is $12,398. Okay, so, but that's where we got taxes we talked about. That assessed value times the millage, and there's a millage code in the upper right, but that's not actually the percentage, equals the taxes. Now, they show you how you come up with your taxes here and what different assessed value the property has for different purposes. But if you go down the left-hand column, you see all the different exemptions you could have. We talked about homestead exemption, and there's an additional homestead and a veterans and a senior, and all these are things that reduce that assessed value to what are the taxes going to be charged on. And then the taxing districts are up top, the county taxes, the school board taxes, whatever city you're in taxes, and the independent and all the other things like hospital district and fire district and all these other. These are the guys levying taxes. And this is the amount of taxes they're going to assess them on. Now let me tell you what we have learned is going on this piece of property, just so you'll be aware of it. If you go back up to the top where we did those years, notice for the year 2015, there's no value there for the building because it's been demoed. The building is gone. Prior years, the building was assessed at $210,000. Sometime during 2014, the City of Fort Lauderdale's retirement fund that owns this knocked down the building so that for 2015 they're only going to be assessed on the value of the land. And if you go to the box below that one in the middle that we did, lower right, called land calculations, this shows you that the way the tax assessor figured out the value of this land was $35 per square foot times 6,113 square feet, and that's how it came up with its assessed value. Now, had there been a building, and there used to be, down at the bottom here is adjusted building square footage. And there would have been some more entries in here where they'd have told you how they figured out the taxes based upon the cost to rebuild, the sticks and bricks, value per square foot for construction. Now, most importantly, and the reason we're here, but I wanted to give you that background of what this sheet is the figure on the left, the sales history. This is where they're going to tell you the sales history of this piece of property. Now, if you would, for a moment, I'd like you to set that sheet aside, be able to refer back to it as we start looking at these deeds. The one at the very bottom right. Now, here's what's going on. Dates of deeds, types of deeds, sales price, and the OR book and page, that's the recording reference of the deed and the sales history here. We're going to start with the one at the very bottom. It has no information regarding it. OR book 9149, page 476. So please go to the first deed I sent you, the next page. Look over in the right-hand margin. You see Official Records Book 9149, 476. Now the way you got this, when you're in the property appraiser site, you simply click on that 9149, 476, and up will come this deed. Nicole, the first deed. You look like you're floundering.
Oh, I found it.
Okay,
I
right-hand
couldn't
margin.
see it.
Okay, that's the recording reference. So the way we've gotten each one of these deeds that we're going to talk about is you click on this OR book and page recording reference, and the deed pops up. And now you have deeds affecting this piece of property, starting with this first deed in 1980. So let's talk about this deed for a minute and what we've learned so far in the deeds chapter and what it shows us. Now this is in 1980. In the old days we used Ramco forms in the upper right. You see, this was a form where you just filled in the blanks, and that's what we did in the 80s. But in the upper left you can see what the name of the form was. It's a warranty deed from a corporation to a corporation. So somebody reached in a file drawer and pulled out the right form for that. That's how I used to do it. So, pretty clear this is a warranty deed because the first three words, this warranty deed. Dated by, that's 1980 deed, by. This is a corporation. It was a Florida corporation. That was the seller. Interestingly, it says, this is cute, it says a Florida corporation, no, that's successor to, excuse me. Realty Leasing Corporation of Georgia, if you'll see 2 lines down, is a corporation existing in Georgia. But it was a successor to 303rd Corp, a Florida corporation. There was a merger of these 2 corporations. It resulted in Realty Leasing Corp deeding it now. Its office address, hereinafter called in small print right next to where you see 40 cents, hereinafter called grantor. Remember, that's the seller on a deed, is the grantor. 2, deeding to another Georgia corporation, whose address is, this address has to be on the deed because that's where the property appraiser, the tax collector is going to send the tax bill. Now, it says, witnesseth the grantor, the seller, in consideration of $10. They always say $10. Nobody puts the real price in there. Does hereby grant, bargain, sell, alien, remise, release, convey, and confirm. Sell. Unto the grantee. That's the second party we named up there. That's certain parcels situated in Broward County, Florida. Now we have a legal description. We're not going to go through the legal description now. That's on the subject of the next chapter. We're not talking about legal description. But all of the deeds here relate to this legal description, which is a bunch of lots that we now know are located at the corner of at 300 Northeast 3rd Avenue in Fort Lauderdale. Okay. Down at the very bottom, just before the together with, 2 lines. Subject to. So since this is a warranty deed, the grantor says, yeah, I'm warranting the title, there are no liens. Subject to any unrecorded documents. That's pretty obvious. Subject to restrictions, easements, and rights of way of record, zoning and building code regulations. So the seller is saying, I'm warranting the title of the buyer, except for these things. The rest of this is mumbo jumbo, the together with and to have and to hold, but to have and to hold in fee simple forever. We talked about fee simple. That's the estate. Yes, sir. Is that a question?
Yeah. Before you had mentioned that you didn't need consideration for a real estate contract.
Okay, say again, I'm sorry?
That you did not need consideration?
You did not need monetary consideration, what I told you. You do need consideration, but I told you to enter a sales contract,
Oh,
you
right.
didn't need a deposit.
Okay,
You
so
needed
like on
consideration
this-
was two promises.
Is that?
This
Like you said, you always
is
see
an
$10.
archaic recitation of consideration. It's in every deed. It's not necessary.
So could you put zero?
I'm sorry?
Could you put zero?
You could say zero. People often do say zero when it's a gift. Sometimes people put it in their love and affection, when it's a mother to daughter, for example. It's traditional to recite what the consideration was, but it's not required. But you're almost never gonna find the real price there.
I'm just wondering, like, if anybody ever challenged that, did you give them $10? Nobody gives even $10.
No, but, and this one you don't know, but in the next deal is gonna say $10, and you're gonna see the price is $2,195,000. So, but it's gonna say $10. This is an archaic common law carryover bunch of crap that everybody does in deeds, but it's not required. And we talked about the elements of a deed, we didn't talk about consideration as one. Okay, now, the next bold print, beginning with "and," here's where we get into, it's a warranty deed. And the grantor hereby covenants with the grantee, that lawfully sees and fee simple, okay, that it has the good right and lawful authority to sell and convey the land, and that it hereby fully warrants the title of the land and will defend the same against the lawful claims of all persons whomsoever. Remember we talked about that's the statutory language in Florida for a full warranty deed, warrants the title against the claims of everybody, all persons whomsoever. And that the title land is free of all encumbrances, and then it goes on to say, except whatever's a record, and except for the real estate taxes. Because here on February 16th of 1980, the real estate taxes for 1980 were a lien as of January 1, even though they couldn't be paid until November. But it's a lien, so he's saying subject to the lien. Now, in witness whereof, the grantor, that's the seller, has affixed its corporate seal, because this is a corporation. Over the left you see the corporate seal. Signed, tiny little print after Alan Morris, President. Attest, traditionally we used to put President and Secretary, because in the old days that was a traditional way of selling property. The President signed, and the Secretary attested to say, yeah, he's really the President, and the Secretary is the one who carried the corporate seal around in her purse and slapped it on the deed. That's why we had this Assistant Secretary over there, Diane something. Two witnesses. The stamp in the middle shows you it's been recorded, but you knew that because you saw this OR book and page over on the right. So the two witnesses, that's the attestation we talked about, attested by two witnesses. And then at the bottom we have the acknowledgement. That's the notary public. This deed was signed, it's Broward County property, but it was signed in Dade County. And the notary says that Alan Morris and Deanne whatever, President and Assistant Secretary of the corporation, right underneath the word President, acknowledged executing the same. That's an acknowledgement. They acknowledged that they signed it. Witness my hand and seal, the notary signs it. Now it's recordable because it's notarized. And that's a deed. That's a warranty deed recorded in 1980. Now look back at your search by the Secretary, on the property appraiser search. Next one up.
Before you do that, is there a reason why the information is not in the sales history?
I don't know. Probably because I think they weren't, in 1980, we didn't have any of this stuff. We're lucky they showed us this 1980 deed. It doesn't go back that far, but they happened to pick this one up.
Okay.
This site was created sometime in the 90s. That's probably why. All right, here's the first one they really pick up. Next deed up, OR book 36610, page 22. Click on that. Up at the very top of the next page. OR book 36610, page 22. You know you got the right deed. That's the next deed. This shows you that the sales price on that deed was $2,195,000 when this property was sold. in 2003, and SW shows that it was a special warranty deed. That's the information you got in the property appraiser. Now we look at the deed. Just so you'll know, every instrument, the last one said it, this one says it too at the top, this instrument prepared by, that's required by law. They won't record it without it. It's called the Scrivener's Act. Every instrument that's recorded has to have a statement on it of who prepared it. And that's simply to help us in the future if there's a mistake to go find who prepared it and try to figure out what's wrong. It's just basically helpful information. Okay. This special warranty deed, okay, that tells you this is going to be a special warranty deed. Dated by, now, by Realty Leasing Corporation of Georgia. Well, interestingly, that was a dissolved Georgia corporation, which was a successor by merger to Venture One Inc. Remember, Venture One Inc. is who got it in the last deed. So now Venture One Inc. is selling it, but they merged and they got dissolved, and so now this is who we have selling on their behalf. With their address, hereinafter called Grantor, to Los Olas Properties Inc., a Florida corporation, having its address at Grantee. So this is your seller and your buyer in this deal, Grantor and Grantee. Same stuff, Grantor in consideration of the sum of $10. Well, we know the price was $2,195,000, but in consideration of $10, because that's what deeds say. Same kind of language. Hereby grants, bargains, sells, aliens, remises, releases, conveys, confirms unto the grantee. Legal description. Property again. Subject to. Lots more subject tos in here, but this seller is wanting to tell this buyer the title is subject to all the following: taxes, zoning, restrictions, matters on the plat, public utility easements, da-da-da-da. So this seller is saying, I'm going to warrant the title to the buyer, subject to the following things. Down at the bottom, last paragraph, and again, grantor hereby warrants to the grantee, grantor lawfully seized, good and right lawful authority, grantor warrant the title, against the lawful claims of all persons claiming by, through, or under the grantor, but no others. Special warranty deed. Seller says, I'm warranting the title only for people who claim through me, which means only for the period of time that I've owned the property. Okay.
What's your relationship with this property?
What's my relationship?
Yeah.
I represented the buyer in this deed.
Okay.
And I wouldn't be talking about my client's business, except this is all recorded. This is all in the public record, so this is common knowledge.
I got you.
Okay, top of the next page. It's going to get signed now. Corporation's going to sign it. Vice president this time. 2 witnesses. Our law now requires, you remember in the last deed we just had 2 witnesses signed. Our law now requires that underneath each witness's name they must print their name. That's to help us find the witnesses when we're trying to prove up this deed. So we print the names of the parties who were the witnesses. We got a corporation, this time 2 vice presidents signed because they both wanted to. One was in, we have 2 acknowledgments. One was in Miami-Dade. That was the acknowledgement of the first guy, Alan Morris, the vice president. And the second guy was in DeKalb County, Georgia. That's Atlanta. So he signed it up there, so that's why the bottom notary is a Georgia notary public, and the upper notary is a Florida notary public, and they're telling you where they took the acknowledgments of these guys, where they say they acknowledged before me that they signed this instrument. So that's a special warranty deed. Now, next, you look back at your search, and you see the next thing, interestingly, OR Book 48269, page 1846. Well, that ain't a deed at all. That's a certificate of title. You look at this next instrument and see up at the top, 48269, page 1846. Yep, that's the instrument they're talking about. Here's what happened. This is the end of a lawsuit. Seacoast National Bank plaintiff had a mortgage on the property, foreclosed the mortgage, took the property away from the defendant, Las Olas Properties, Inc., and there was an auction, and the bidder at the auction obtained the certificate of title. So this is the clerk of the court, as a result of a mortgage foreclosure, giving a certificate of title to, lower left, was sold to TC Property Venture LLC in Stuart, Florida. That means that's who showed up at the courthouse foreclosure auction and bid for this piece of property. That money gets paid to the plaintiff in the lawsuit, the bank, and the clerk then deeds the property to the buyer at the auction. So the property appraiser, trying to make a chain here to show what happened, next posts an instrument here saying the consideration was $100 because you see in the lower left, the bank only bid $100. That's because the bank is who bought it. So they only bid $100 in the foreclosure sale. So the price, according to the property appraiser, is $100. CET is a certificate of title, this certificate of title. So here, the court transferred the title to TC Property Venture LLC. So TC Property Venture gets title in October of 2011. And 2 months later, next month, November 30th, next entry, November 30th of 2011, by a special warranty deed for $3.5 million at OR Book 58372, 1851, top of the next page, there's your recording reference. You know you got the right document. Another special warranty deed. So, party that bought this at the foreclosure is now giving a special warranty deed from TC Property Venture LLC, a limited liability company that bought it at the foreclosure sale, deeds it to the Board of Trustees of the City of Fort Lauderdale General Employees Retirement System. This is the retirement fund that invests in assets for retired employees of the City of Fort Lauderdale. They decided to buy this piece of property as an investment. So, they bought it from the entity that did the foreclosure. We got the legal description again. We got subject to, because this is going to be a warranty deed, so they're going to put subject to taxes and restrictions, reservations of record, da-da-da-da. We're going to go down to the clause above and witness whereof, and in small print, and the grantor hereby fully warrants the title, will defend the same against the lawful claims of all persons claiming by, through, or under the grantor, but none other. Special warranty deed again covers only the period of time that this entity has owned it, which, as you know, is 2 months. The seller here bought it at a foreclosure sale a month ago. So he certainly doesn't want to warrant the title for 200 years. Has only owned it for a month, number one, and number two, bought it in a foreclosure sale. So not real excited about warranting the title there either. So carefully, this seller says, I'm only giving you a special warranty deed, which says for the 2 months that I've owned it, I haven't screwed it up. You see this deed is signed by TC Property Venture LLC, a Florida limited liability company. And lo and behold, look who the managing member is. Why, it's Seacoast National Bank, the bank that foreclosed the mortgage. So this is really the bank. The bank bought it at the foreclosure sale. That's why the consideration was only $100, because they had a mortgage. Got 2 witnesses, printed names under the signatures, attestation, as we talked about. Now, follow the way the signatures are working here. We've got a Florida limited liability company by Seacoast National Bank, its managing member. Remember, managing member is who signs for an LLC, and it's a corporation. So a senior vice president, Kevin something, is signing on behalf of the bank, which is a corporation, which is the managing member of the LLC which is the seller. Next page is the notary acknowledgement. Signed and barred, notary seal, couldn't be recorded without it. This big old, this is not an official copy, that's what you get when you print these documents from the website. This is not a certified copy. If you want a certified copy, you go down to the courthouse and you pay them $2 and they say it's a certified copy, and like we talked about, that's the kind of that you can use to record for judgments and stuff. But this is good enough, this works. Now, last instrument. Quitclaim deed. Because Las Olas Properties previously owned this property, and because the title was foreclosed and taken away from Las Olas property, and just in case there were any defects in the foreclosure proceeding, the title company wants to be real careful, and if Las Olas Properties still has any interest whatsoever, probably doesn't, but it might, but if it did, let's get a quitclaim deed from Las Olas Properties to make sure that whatever interest they had, because remember, really, 2 instruments ago, they're the last person that got a recorded deed on this property was Las Olas Properties, Inc. Then there was a foreclosure that took them away from them, but the last recorded title holder was Las Olas Properties. So to be safe, title company decided, let's get a quitclaim deed from Las Olas Properties, Inc., a Florida corporation, called grantor, to the same buyer, city trustees for the Florida retirement system. So as we talked about, you remember I told you, the grantor may be the seller, but maybe not the seller. In this case, you're not the seller. The grantee in both of these deeds is the buyer, because the city paid $3.5 million for this piece of land, at which time it had a building on it. The body of the deed, the witnesseth, you'll see is a little bit different. Right in the middle of it, the grantor does hereby remise, release, convey, and quitclaim unto the grantee all the right, title, interest, claim, and demand which the grantor has in that land set forth below. Parentheses, it doesn't say that, but what it means is, if any. Because in a quitclaim deed, maybe they don't have any interest. But if they still had an interest, this deed is going to eliminate it. Same land. Notice now there are no subject to, because there are no warranties. Grantor is not warranting the title, so he doesn't have to say what it's subject to. And down at the bottom, you don't see any of this. And I'm telling you the title is good, and I'm warranting it to you against anybody claiming through me or for the whole world or whatever. There's none of that stuff. There are no warranties. Basically, grantor says, I'm signing it, and that's it. That's all he's done. So Las Olas Properties, president, 2 witnesses, notary, signed it, recorded. If Las Olas Properties, Inc. still had any interest in the property, this eliminated. And that's it. And that's where we are. And that's the last deed recited. Last 2 deeds recited you'll see on the property appraiser's website here. Both of them are to the City of Fort Lauderdale Retirement, and up at the top, that's who it shows as a property owner. That kind of ties all this together, I hope. Yes, ma'am.
What is the incentive to Las Olas Properties to signing the quitclaim deed?
I can't tell you. To be a good guy. To be nice. To be nice to the city. They didn't have to. It's nice to get along with the city. That's enough right there. There's more, but I mean, if the city asks you for a deed to property to something you know you don't own anyway, like I told you, I'll give you a deed to this building.
Yeah.
Why not do something nice for the city? Maybe it'll get you a favor someday. Can't do you any harm. But they'd already lost the property anyway.
Yeah.
So why not? Yes, sir.
I noticed on the last 2 documents, the description, the property description changed a little bit. There's like a second paragraph added to the property description.
It has.
What's going on there? I tried to
Okay.
read it, but it's like a
I'll
different
tell you.
language.
The second paragraph says, further lessen except those certain portions of lots 25 and 26. Okay? This property was about 20 lots on the corner of Southeast 3rd Avenue and 3rd Street. And at some point, while Las Olas Properties owned the property, the county came to them and said, we'd like to change this corner to a round corner. Would you please deed us, the county, this little triangle thing so we can round off the county, round off the corner? And that's what it is. So that going forward, when people start conveying it now, yes, all these lots again, but it's less this little triangle off the corner. And that's what that less and except portion describes. Less and except that certain portion, and
Conveyed
it goes
to
on, you
Broward
see at the
County.
end, conveyed to Broward County by warranty deed recorded in book of page.
Okay.
Okay, any other questions? I'm hopeful that that's about the most practical thing that we've done in the class. I hope you'll feel so too, that it'll help you find properties going forward, find information about properties. Don't be afraid of this website. It's got beaucoup information in it that's worth having. I shoot at them occasionally because I don't like what they do with their legal descriptions. But Lori Parrish is good. She knows what she's doing. The people down there know what they're doing. And they're even fairly cooperative if you give them a call. Yes, sir.
Does she run like unopposed, or has she been there for how many years?
I think she was unopposed. Yeah, thank you. I can't remember.
How long is her term?
4 or 6 years, one or the other. Don't recall. She was a county commissioner.
Okay.
And then this is a political job, just like, I mean, it's an elected job, just like supervisor elections and others. But she ran, I think she got term limited off the county commission and ran for this. And I think she was a realtor.
Yeah.
But she's a smart lady, very smart. People used to shoot at her thinking she was some blonde bimbo politician and didn't know anything. She's done a hell of a job with this office, and it's good. It's very smart. Any more questions? Yes, sir.
Not about deeds, but if you're gonna go put an offer,
Sorry, I can't.
if you're gonna put an offer in at 125 Las Olas Boulevard,
Huh?
and you wanna call the company 125 Las Olas LLC.
If you want to name the entity that you're going to use to be the buyer?
Right.
Okay.
Same as the building. Do you have to have that entity already started before you do the offer?
Bless you. No,
Or can you do the offer, and then if it's accepted, go ahead and start the entity?
that's exactly what you do.
That's what you do?
Remember in our form contract, it said, this contract may be assigned to an affiliated entity
Right.
and otherwise is not assignable. That's what we're talking about. You probably would put the contract in your name as a buyer,
So you just do that, you
Yep.
do it in your name, and then,
and then you
Okay.
decide this, then you go through due diligence, yeah, it looks like this thing's gonna close, okay, it's worth my money, I'll go ahead and form a corporation,
gotcha.
have it ready for closing, but as we talked about, you gotta have it filed by the time of closing, because a deed to that entity, if it's not formed yet, is void.
Right.
But there's no reason to form it just to go make an offer on a piece of property, definitely not. Anything else? Okay. Next chapter. So that was deeds and samples of deeds, and property appraiser stuff is just an aside, but I hope it'll be helpful to you. And we're now going to go to chapter 17, which is legal descriptions. And of course, every one of those deeds had a legal description in it. And I know we've alluded to this some, but street addresses are not legal descriptions. Street addresses are for the post office. Bless you, but we use them. We used them to find this piece of property, because that's how she indexes property, among other ways. And it's an easy way, because if you're doing a drive-by and you see a piece of property and you want to get information on it, you don't know what the legal description of that thing is. But you know it's at 300 Northeast 3rd Avenue, so you search that, then you'll find the legal. So legal descriptions are the description of a parcel of land, the materials say, that will be accepted by the courts because it's complete enough to locate and identify the premises. Meaning, and here's the test we always talk about, can a surveyor locate the property? from the legal description. If the legal description is good enough that a surveyor can go find it for you and draw it for you, then it worked. And if he can't do either, you're really in trouble. If he can find it, but he can't draw it because maybe the legal description is defective, you may have a problem. Understand that a legal description, I want to make this distinction between legal description and a boundary. Legal description is the description of this piece of property. It creates the boundaries. This is a boundary. That's a boundary. That's a boundary. But the terms get used interchangeably and confusedly by people saying, well, what are the boundaries? Well, you got to have a legal description to see what the boundaries are. Okay, well, we're talking about legal descriptions. Now, I want to say now, I'm going to say again at the end, I cannot, if I stood up here and screamed it for the rest of the day, overemphasize to you the importance of having a survey. You've got to get a survey of a piece of property. Now, we're going to go through a survey after this chapter, and I'm going to show you some more why. But if you don't take anything else away from this course, please learn that. Don't close a piece of property without a survey. Because, think about it for a minute. That legal description that we looked at, you know what's on there? You know, is there a building on there? Isn't there a building on there? Is it the building you think you're buying, or isn't it? I mean, that's one of 100 reasons. But you sign a contract to buy lot 55 of Happy Acres. You hope it has the house on there you think it was. It's got the street number, but you want the surveyor to draw and show you the size of the property, and most importantly, show you what's on there. Is that house on there? Is the neighbor's house on there? Is the neighbor's fence on there? Is the neighbor's pool half on there? What's there? What's on that legal description? You got to know. So, we're going to work on legal descriptions, but bottom line, we're going to make sure a legal description is written properly and how they're written, but you then need a surveyor to show you, so what does it mean? What is it? All right. There are 3 types of legal descriptions. Anybody know what's up here?
Oh, press the
On the right.
Is there a button, you think?
big
Yeah,
black
on the
button.
right there. The black one.
No,
No, no, no,
on
behind
the
the
wall.
wall.
On the
Under-
wall.
On the wall.
Next to the phone.
Black switch, thank you. Okay, let me see if I can draw just simply a piece of property and say we're going to try to figure out the legal description of this piece of property. Now, there are 3 ways you can come up with a legal description of this piece of property. The first is called meets and bounds. What meets and bounds means is you find a certain point and then you use compass descriptions and distances to create the legal description of the piece of property. Okay? So, this happens to be a lot on a river, on a strait, and their houses next door. Their lots next door. Let's do 1, 2, and 8. Say that 1 through 8, now we're going to start 1, 2, 3 again. So, meets and bounds, and this is north. Okay? Meets and bounds is, go to a fixed point that you can locate. Let's make one up. Down here
McDonald's.
is a street. Okay? So a surveyor may say, go to a point on the west right-of-way line of such and such a drive, and the north right-of-way line of this street. So if you said, go to a point that is on the west right-of-way line of this street, that would be this side, right? And on the north right-of-way line of that street, by God, you'd have this point. Surveyor can locate that. Anybody can locate that. You go to the city right-of-way maps, and you'll find the width of the street, and you'll find maps, and you'll go out there. You probably, believe it or not, will find a pipe or a nail or something. Something will be marked that corner. That's a monument. That's called a monument. In the old days, it was a rock, it was a tree. Now, I'm sorry? Rivers are weird. Rivers it could be rivers, but rivers move, and that gets a little weird.
Gets weird.
So, in a meets and bounds survey, you create you make a reference to some sort of a monument, something that everybody knows how to find, and that's called the POC. That's the point of commencement. Okay? So the surveyor says, go to the intersection of the west right-of-way line of Ocean Drive and Northeast 20th Street. Now we got that. That's our starting point. That's our point of commencement. Then, by directions and distances, which are called calls. Now, by calls, we're going to get to this lot. He's going to say, go west along the north right-of-way line of 20th Street. Go west along the north right-of-way line of 20th Street for a distance of 200 feet to the point of beginning. 200 feet to the point of beginning. This point. That's the POB. That's the point of beginning. Now, in order to talk about lot 1, he's now going to say, go north 120 feet to a point on the south shore of the river. Here's that. And he's going to say, go west 80 feet to a point on the south side of the river. Now he's going to say, go south 120 feet to a point on the north right-of-way line of 20th Street. Then he's going to say, go east 80 feet back to the point of beginning. That's a meets and bounds legal description. You're used to looking at this and saying, this is lot 1 of Harbor Beach. But it's also this. And you can also get to it by a meets and bounds legal description. Every piece of property, everywhere, can be located by a meets and bounds description of some type or another. It can be horribly confusing. In order to find a point in the middle of nowhere, you might have to go to the foot of Mount Rushmore and go 220 miles south to come to the point of commencement, or the point of beginning of your legal description. But the point is, you start at a point of commencement. From there, you take a call to the point of beginning. And then, by calls, you create a legal description, and it must close. If it doesn't close, it's no good. If he says, now go east 78 feet instead of 80 feet, it's not going to close. You don't have a parcel now with boundaries. Now, they're not always nice and square like this either, you know, sometimes they're all over the place. Usually, they're not nice angles like this go north. They're more like go north 45 degrees west, or go south 45 degrees east, go off this way, and they all over kind of stuff. But the point is, that's the concept. They get a hell of a lot more complicated. And these angles in degrees are angles with minutes and seconds. So they are degrees down to the thousandth, I think, of how they measure the angle. And they measure feet to the hundredths. 80.00 feet is what it'll be. They get a lot more technical in this, but that's the drift of it. That's a meets and bounds legal description. You can do that with any property anywhere. Okay, that's meets and bounds, a call, angles and distances. Know that on each of these corners, the surveyor is going to put in an iron pipe or a cap and a nail or something. They call them iron pipe. They're pieces of rebar. The surveyor will hammer a piece of rebar right on that corner, into the ground.
Those are the things that keep tripping over.
Yeah, exactly. Rusting and bending, and they're off. What they'll also do, you often see in driveways, you see what looks like a little bottle cap with a nail driven through it?
Yeah.
That's a surveyor's ornament. That's what they do when they can't pound and grass. And they're on seawalls. There'll be a seawall along here. In the seawall, each place along here, there's going to be a nail and a cap. If you look real closely, there's a surveyor's name engraved in there, and there's even a number on it. And that way, he said, that's how surveyors keep track of all this stuff. That the boundaries of this are this nail and cap number so-and-so, and this pipe, they call iron pipe, which is a piece of rebar, have a little tag on it. Usually when they put them in, you'll see a little flag on there, and they all go away. But the piece of pipe stays there. So that's how a surveyor, by meets and bounds, could describe this piece of property. Okay, now, the second way is the rectangular survey system. This is really obtuse. I'm going to try to give you just the basics of it. But what it's all about is that this is Lewis and Clark type stuff. The government in the 1800s went out and surveyed the whole country, including all of Florida, and divided all of the land into sections, townships, and ranges. Townships and ranges are like our GPS calculations that we all use today. Of how many degrees east and west, how many degrees north and south. So, in this government survey, they created these township lines every 6 miles. And they created range lines every 6 miles. We're talking the whole country. Townships will be township 43 north, for example. That means wherever the hell they started down here, 43 of these 6-footers, of these 6 milers, 6 miles, was one of these townships every 6 miles from wherever they started were 43 up. So we're at township 43 north to be this line. And same thing east and west. We have ranges every 6 miles. So we have range 23 east, range 24 east. What that means is, must have started over here. 23 times 6 miles got them to here. 24 times 6 miles got them to here. So pretty soon the whole country is divided into these things. These are 6-mile squares. Every one of them is a certain township, so all of this is Township 43, and all of it is, really, Range 22 East. That gives us a block of land, 6 miles square. Then, they divided this into 36 squares. Those are called sections. And that's a section. There are 36 of those, and each one's a square mile. So, and they had a uniform system of numbering these things. I've forgotten how I used to know this stuff cold, but like this would be 1, 2, 3, 4, 5, 6, and then weirdly 7, 8, 9 coming back. So that you could predict there are going to be 36 of these, so that therefore to find this piece of property, which may be in the middle of the Ocala National Forest, this 1 square mile of land is going to be Section 2, Township 43 North, Range 22 East. Okay? So now in the middle of a forest, you found a square mile of land. Okay. Now, then based on that, we start, now we have this, just Section 2 now we're talking about. Section 2, Township 43 North, Range 22 East. Here's Section 2. Section 2 is a square mile. This was 6 by 6. These are 1 mile each. Square mile is 640 acres. Now we start describing land by saying this is Section 2. Okay? Now we start talking about the northwest quarter of Section 2. The southeast quarter of Section 2. Each of these quarters is 160 acres. Or we talk about the north half of Section 2, the south half, the east half, the west half. The west quarter. This thing just keeps breaking down and down and down, and smaller and smaller and smaller and smaller and smaller and smaller. Okay? Now, to talk about this piece of land right here. Say we want to talk about this one. How are we going to describe it? And that may be, let's see, I'm not going to do that. That's 10 acres, okay? How are we going to describe this 10 acres inside that X? Well, it's the southeast quarter, okay, of the northeast quarter of the east quarter of the northwest quarter of Section 2, Township 43, Range 22. And you keep going down and down and down. And pretty soon, you start talking about the south 20 feet, or the east 40 feet. And pretty soon you create a legal description. And you create a legal description here of this, saying this is the east 40 feet of the south 20 feet of Section 2, Township 43 North, Range 202 East.
Oh my
And a
gosh.
surveyor can find it anywhere in the country based on a description like that. That's called a rectangular survey system, but these are the ones that you see all the time, where you see the northeast quarter, the southeast quarter, the quarter, section, township, range. You can find anything like that. And it's the same thing that we do now with GPS. But with GPS, we're doing it with lat longs. But it's the same thing.
Is there a
Lat
system?
longs are coordinates, and they're moving, and they narrow you right down to a little spot. And that's the same thing that this did, but remarkably, they did this 200 years ago. Yes, ma'am?
Count the ranges from left to right, like 1, 2, 3, instead of 1, 2, 3 different.
I'm sorry?
Don't you count the ranges?
I forget what direction they go. Did I go the wrong way?
I think it's
I don't
1
know.
on the 6 and 1, 2, 3 from left to right. Right?
Assuming if you started ranges here,
Where,
it would be 22, 23, 24. It depends on where you start measuring. If you start measuring here, then the ranges go east, okay? Or, if you start measuring here, you also have ranges west. You got to figure out what's going to be your baseline, whatever that baseline is. You have townships north, and you have townships south. And if this is your baseline, you have ranges east, and you have ranges west. Did that answer your question?
no.
Huh?
I
No?
think that when you count ranges and you put it on the square, on the square there, you start like, instead of the 6, where you have the 6 there, 1, 2, 3, and you start like that.
These sections, I don't know, there's a picture in the book.
Yeah.
It is what it is.
Yeah.
I don't know. I'm not trying to teach surveying law.
No,
I'm just
but
trying to give you the idea that
We need to
every
know that.
surveyor knows, as I said to you, I don't remember which direction these things go. Wherever they go, every surveyor knows that all 36 go a certain way, except, every surveyor will tell you, except in a few places, they decided to go the other direction. But the surveyors know that, and that's why a surveyor can value the property. And the test of all this, as we talked about, can a surveyor find a piece of property? Can a surveyor show the judge, based on your legal description, can I draw it? Can I find it? Do I know what the boundaries are? Is that making a satisfactory legal description? Okay? That's number 2. That's called the rectangular survey system. Farmland is all done this way. All farms are like this.
Makes sense.
You used to hear stuff like the East 40. You know, Green Acres was the East 40. Well, that may have been the East 40 acres. It may have been the East 40 feet. It may have been the East 40 miles. You know, but the point was, that's where all these things come from, and they come from certain meridian lines wherever they are, and I don't have a clue where they are or where they start, but the surveyors do. Okay, now lastly, the final way to describe property is by a plat. And frankly, this is what you're going to use most of the time. A plat is a map. It's a recorded map of lands. And on the map, they're going to show you lots and blocks and streets, and it looks a lot like a survey. Excuse me, in the sense that it was drawn by a surveyor, and it looks like a survey, but here's what's going on. If this were a platted subdivision, what this would mean would be that some developer owned all his land, and he drew it all on a map called a plat, and he created all of these lots, and he numbered every one of them. And this one would probably be Block A, because this is Lot 8, so he's got a Block A, and now we're going to start into Block B. So he would draw on this plat all these lots in Block A, and all these lots in Block B, and it probably would be some on this side of the street, and there might even be another street down here, and more lots down here. Records that map in the public records. It's drawn by a surveyor. On the survey are all these little marks. It's a full legal description of all of the land in the plat. All this land with its full legal description is on there. The developer signs it and says, I'm recording the plat of Harbor Beach. And henceforth, all of this land in my legal description, which is pictured here, will be known as Harbor Beach. And I hereby dedicate all of the streets to the public. And that's how the city gets the streets. Makes the developer build them, but then he dedicates them and gives them to the city. And that map gets recorded in a book called the Plat Book. And it'll be a certain page. So forevermore, after that's recorded, when we want to refer to our lot 1, we don't have to do all this. We don't have to do all this. We simply say, Lot 1, Block B, according to the plat of Harbor Beach, as recorded in Plat Book 2, page 22 of the Public Records of Broward County, Florida, and they all know exactly what that lot is. And that's platted. And that's a platted lot. But remember, we were able to describe it all these other ways too. So basically, every piece of property can be described 2 or 3 ways. It can be described the first 2 ways we talked about, with meets and bounds, or by the government survey. And if it's platted, it can also be described by reference to the plat. In that case, there are 3 ways to describe it. Yes, ma'am.
So when they're referring to replatting, is that because way 1 and 2 conflict with the platted map?
Okay, when they refer to replatting, is that what you said?
Yeah, like I've seen it before, like you apply for replatting because the lines were drawn wrong on the plat map.
Absolutely. Mistakes get made in plats, just like they get made in all kinds of surveys. When you record a plat that is a replat of a prior plat, you might decide these lots didn't sell worth a damn. This is waterfront property. I couldn't sell a single one of these lots. This is bad news. I'll record a replat. When you record the replat, the legal description of your replat, believe it or not, is all the lots and blocks in the old plat. That's your legal description. And you record a new plat, and this time you do bigger lots. And maybe they'll sell better. So that's the replat of Harbor Beach, with bigger lots that I can sell for more money because they're on the water. And you can replat again and again and again. Now, understand if you would, every time you file a plat, just about every government agency that you've ever heard of has their hands out for a fee. It takes 1.5 years to 2 years. Everybody and his brother has to sign off on it. Sanitation and sewers and fire departments and city engineers, city building departments, utility companies all have to agree, you know, where our utility easement's going to be, where our line's going to go. It's not fun. It has to go before the commission, it has to go before the planning board, it has to go before the commission twice. Good 1.5 year process to take plain old, this little piece of property and draw your map. You create this, and to get it all approved by the government and get it recorded in the plat book, you got to figure out 1.5 years.
What kind of cost is involved in a small?
It just depends on how much land you have, and lots of costs of engineering, lots of costs of surveying, lots of costs of buying politics and paying your lawyers to get votes. You know, like the golf courses in Tamarack that they're trying to plat. I mean, you can imagine the different levels that has to all go through, and of course, understand that neighbors fight things like this, you know, when you're turning a golf course into housing. I mean, we're talking about platting in those cases. That's how they're going to turn a golf course into residential lots. They're going to file a plat. And every time the government has a hearing on the plat, and all the neighbor people who like the golf course are going to come in and scream and yell, so it gets very political. So I couldn't begin to predict the cost figure. Some plats are 1 lot. Some plats are 1,000 lots. And governments have different regulations about minimum lot size and all that kind of stuff, and you gotta follow all that stuff. It's crazy and time consuming. But going forward, think how much easier it is now when we're doing our deeds to do Lot 1, Block B of Harbor Beach. than it was to do the south 20 or the north 80 or the east 1 or go to the rock and go to the river and all that kind of stuff. I mean, and it's a lot easier, it's a lot harder to make a mistake. That's good. Okay, that is legal descriptions.
You can use any of them for your deeds, either one.
You could, if you had platted property, you'd be crazy to do any of these other things. I'm just trying to make the point that every piece of property is all of these things. But once you have a platted legal description, of course you would use it. And secondly, and part of my lesson again, you're going to do what the surveyor tells you to do. Because the surveyor is the test here. If the surveyor says this is the proper legal description of this property, then that means he can get in front of a judge and say, this is right, and I can defend it, and I can find it, and I can draw it. And if you try to change it, at your peril. Okay. The chapter also talks about boundary disputes. We're not going to go there. If there are boundaries, there will be disputes. People fight over property boundaries. They have since the Bible, and they will in the future. Boundary disputes are another reason to get a survey when you buy a piece of property. See if some guy's fence is 10 feet onto your property. There's a clue. I'm not going to get along with that neighbor. This fence is 10 feet over onto my property. He thinks it's his yard. He mows the lawn on that side of it, you know? I think it's mine. You're buying a boundary dispute. But if you didn't get a survey, you'd never know that. And people get into it for all kinds of reasons over boundaries, over trees, over boundaries, over noises, over kids, over, you know, I mean, boundaries are, you know, fences make good neighbors. Fences in the right place make even better neighbors. Okay, now, I'd like to discuss with you the survey that I sent you. I'm going to try this one more time because I had this thing up here this morning. Fred and I had it turned on, and I'm not sure why we can't do that again. But you know, I'm not going to go there. Here's what I want to do. I want to walk through a survey with you, and I want to do it the way I intended to before technology came along to screw me up. I got a survey.
Back up.
Pardon me?
You bring the screen down and you upload it from your email.
What? I'm sorry. You could do what now? You could scan this and put it up there. Is that what you're saying?
You can take that. I mean, it was up earlier today, wasn't it?
Yeah.
No, but we're saying the internet.
Can everybody see this if I put it up here? I want tape.
PCPA, that's not working. The internet's working.
I'm sorry? The internet is now working, is that what you're saying?
Oh no, I was on that TV.
Yeah, he was watching some videos during the election, so he said it was back up. It's up, Mike? Did the video work?
Give it a try.
Can somebody get on here, the email that I sent you these documents with, and the attachment, and if we can blow up the attachment, it'll be the same survey that I'm trying to show you.
If anyone has
try that.
USB, we could just upload it.
Internet is working.
It is working?
Yeah, I think so.
Otherwise, we're going to have to look at this piece of paper, but I want to walk you around the survey, and I want to tell you why I think it's important, and why
All right, we in there.
why you need one, and what you learn from.
I got it in my email, so I'm gonna pull it up.
You got it in your email?
Yeah.
Okay, cool. Cool. And there it is. Now, we just got to blow it up.
Screen down.
Well, that's blown up.
Pull the screen down.
All right, yeah, put the screen down, you bet. Cool. Can you make it a little smaller?
Let me see what.
And Juan, can you
A
tell
little
us
bigger.
what you learned about it while you're up there?
It's downloaded.
Yeah, it's down.
I did, but it pops up. It pops up big. See?
You can zoom out.
Oh.
Down there in the
Oh,
bottom
here,
right.
here.
All right, well, we could move around. That was good. In fact, that's got everything we need to look at. I think.
Perfect.
Cool, thank you.
Good job, man.
Great. Well done. All right.
Get a name.
This is the survey that I sent you. I wanted to send you one of the property that was in all of our deeds, but I didn't have it in, I didn't have it scanned. You rarely get a survey by email because they're so damn big. This is how big surveys are. So you can read them and see them. This is the real, that survey. So this is the size. And obviously, as you're looking at it, it's big enough you can read. As I sent it to you, the only way, of course, was to blow it up. I want to just walk you around a little bit and show you here what's going on and what you learned from a survey. Legal description. We said we want to use the legal description from the surveyor. So the first thing you'd want to do when you got this survey is figure out, is this the piece of property that I think I'm going to buy? This is a building on US 1 in Tavernier in the Keys. So you would go look at, okay, it's on US 1, that's good. It goes all the way from Sunrise Drive to North Sunrise Drive. So that's what I think I'm buying. Yep, I think I'm buying a whole block between those two streets on US 1. And I think I'm buying this building. Does that look like my building? This is a good start. It says one-story CBS building. I don't remember whether it says square feet or not. Split level. One-story split level commercial building, it says. These hashed lines here, that's the building. The piece of property described in the legal description is everything inside these dark lines here. So you're going to take your survey, and you're going to get out there and you're going to walk around the property. These are parking places. What you see in gray here is asphalt, that's paved, like the road is paved. This is asphalt paved parking. Here's a piece of the property, but it's not paved. I think it says vacant wooded, as I recall. So, first and foremost, is this what I think I've contracted to buy? In our first case, I contracted to buy 300 Northeast 3rd Avenue, Fort Lauderdale. Does this look like it? In that case, that would be close. That one that we talked about before goes from 3rd Street to 4th Street on 3rd Avenue. So you'd be able to take a look and see, yeah, this is really what I thought it was. This is a very old plat in the Keys, and interestingly, this property here is in 2 different plats. And in fact, this piece of property, commercial property on US 1 in the Keys, has property in 3 different plats. Here's Tavernier Heights. That was a plat that included all these lots up here. These are not included, they don't have to be on there, but the surveyor's showing them to you for reference. This plat down here is called Tavernier Cove. That includes these lots, and lots 6, 5, 1, 2, 3, 4. These lots, 1 through 6, are in the plat of Tavernier Cove. And if you look at the description, it's going to tell you lots 1, 2, 3, 4, 5, and 6. Last a little something that we'll talk about in a minute of Tavernier Cove. Well, let's talk about it now. lots 1, 2, and 3 in the old plat of Tavernier Cove. This is platted back in 1925 was the date of the plat. Lots 1, 2, and 3 used to come out to here. That was the platted lot line of the old lots 1, 2, and 3 of the old plat of Tavernier Cove in 1925. Well, when they widened the highway, there was an eminent domain taking. We're going to talk about that in another chapter. The government took away from them this portion of lots 1, 2, and 3. So that's why you're going to see up here, what, less the northwesterly 36 feet of lots 1, 2, and 3. Now usually we'd have east 30 feet, west 30 feet, north 30 feet. Remember in the Keys, although we all think the road in the Keys is north-south, it's not. It's tilted diagonally. That's why north is that way. The north is up there. And that's why this part is the northwesterly 36 feet. See, it says 36 feet. That showed that this 36 feet of those platted lots 1, 2, and 3 have been taken by the government. And that's why the legal description is now less. Okay, so in that plat of Tavernier Cove, this plat, we had lots 1, 2, and 3, less the northwesterly 36 feet that's out in the road now, 4, 5, and 6. Those are included in the legal description. In addition, we have lots 6 and 7. Maybe I've got my numbers wrong. 2, 3, 4, 5, and 6. Together with, oh, I know what's wrong. I'm sorry. This, this survey included these 2 lots. Yours does not. You have a later draft. When we first got into the deal, it looked like we were going to get lots 6 and 7 also. And this survey included lots 6 and 7. They're up here across the street. They're not in our deal. They're not in your survey. So when you look at your next legal description, I'll bet you start with 37, 38, right?
Mine says the same.
I'm sorry?
Mine says the same thing as yours.
Yours says 6 and 7?
Yeah.
Okay, well then obviously that's the one that was in the...
It says lots
Okay,
1, 2,
forgive me. But mine doesn't. My printed one here says 36, 38, 37, 38, 39. So it was deleted from this final later draft I have. In any event, in this survey, they're in there. But as it turned out, they weren't relevant to our deal. We didn't get them. They fell out of the deal.
Okay.
But they're in the legal. Most importantly are the other lots, 37, 38, 39, 43, That's these lots, which are 35, 36, 37, 38, 39, 40, whatever that is, 41, 42, and 43. All these are included. Now, in addition, what's going on in this survey, these 2 parts of lots 36 and 37 are not included. So the surveyor is telling us here, together with lot 35, that's the 3rd part up here, together with lot 35 of Singleton's addition to Tavernier Cove is recorded in plat book so-and-so, page so-and-so, that's that plat. He says, less a portion described as follows. So in his legal description, he says lot 35, and now he says less a portion described as follows. And now we're going to get into a meets and bounds legal description. By meets and bounds description, he's going to start here as a point of commencement. He's going to say go to here, which is a point of beginning. Remember we talked about these, point of commencement, point of beginning. Now he's going to describe these 4 lines. And as it turns out, this is an exception. Because he said it's lot 35 less this. And he's going to do the same thing with lot 36. And he's going to have a point of commencement. I'm not sure where he started on that one, but he goes to point of beginning. He's going to walk you around this by meets and bounds. And that's to less that up. So that's your legal description. So now you got a picture. Good, it contains my building. You start going around the edges. Are there any problems I have to be concerned about here? Does anybody's fence encroach on my property? I know you can't see this, but on this line here, there are little X's. You go down here in his legend, you see little X's show you there's a chain link fence. That chain link fence, fortunately, is right here on this property boundary. That's where it should be. If it were onto my property, and it's the neighbor's fence, I know we got a problem. If the fence down here, and I think my property goes to the fence, well, I just found out it didn't go to the fence. I only go to here. So you walk around all sides looking for issues. Boundary problems, utility problems, physical issues, and you take your piece of effort and you walk around the property with it. You look at every one. I mean, when you get down, it's incredible the detail these things get down to. Every little drainage hole, some of them do sprinkler heads. At each one of these corners, you're going to read somewhere there something like pipe found, pipe and cap found with a number on it. Each one of these corners, every single corner of this legal description, the surveyor has put in a monument so that other parties can use it going forward. And that's a survey. Here's a scale, give you an idea what distances are. Every single distance on here, he gives you a call. Each one of these distances, each one of these lots, each one of these full sides, he's giving you the distance. But you can also play with things with the scale. Down here are abbreviations of all the little boogers that he's drawn. This means sprinkler head, this means telephone pole, this means all these little things. So you can figure out what's he drawing for you here. You can see your relationship with the neighbors. In this case, this property was going to be rezoned. Find out who all the neighbors are, who's probably going to come in and fight you on rezoning. You start reading through the surveyor's notes. You want to read everything that he tells you here, because some things may be real important. He may be telling you here, by the way, I want you to notice that there's an issue here or an issue there. Along here somewhere, he shows the location of fences that I can read on mine, where he shows you a fence here. In this corner, he's saying right here that the fence is 1.1 foot either into our property or into their property. But he's telling you in each case, there may be an issue there. This fence is 1.1 foot away from the exact property line. And then, of course, you've got to figure out, does that mean my neighbor is encroaching on me to the fence? Or does that mean my fence is encroaching on the neighbor and really what I think is a foot of my property is his? That's pretty much it. I'd be glad to answer any questions. But that's the gist of what you're looking for in a survey. You match it up against the legal description of the title work that you've been doing. If your legals are close, you use his as best you can. There are distances in here up in these things to the feet, to the 10th in this one, degrees with angles and minutes. All these calls are in there, and they're critical because you're going to use them in your legal description, and there are opportunities for somebody to typo and screw it up. And in the future, you created a title problem. Okey-doke. Questions? Yes, sir.
What happens if you find someone's encroaching on your survey, on your land here?
Well, what happens depends on where you are in the deal. If it's before closing, you tell the seller to go work it out. If it's after you already own it, you got a problem, you need to work it out with your neighbor. You're going to see later in a chapter called where we talk about adverse possession. You know, this concept of squatters' rights, and if you possess somebody's land for 7 years, you own it. That's where the issue gets hairy. If for 7 years their fence is a foot onto your property, and they use it for 7 years and you're fenced out, They may own it. So these are real issues.
Doesn't it require that you know about it though? Because if you didn't know that it was actually on your property until you had a survey done 7 years later, that doesn't apply.
Exactly. You have to be aware of it.
You have to be aware.
Exactly. But my point is, if you're aware of it and you do nothing about it, you ask me, what do? You go work them out, because after 7 years, once you're aware of it, it can ripen into ownership. Any other questions?
You said 6 and 7 is part of this, lot 6 and 7 is part of this property, right?
It was in this draft of the survey in this deal. Here's what happened, it's kind of funny. The seller, this building was owned by the Florida Keys Mutual Electric Company. They built a huge building across the other side of the road, big beautiful new building, and they were selling their old building. They had a legal description of what they owned. Realtor picked up the legal description of what they owned and threw it in the sales contract. My client signed a sales contract, didn't know what it was. Then we got a survey, and we found out, isn't this cool? It includes the 2 lots across the street. Seller went ballistic. I never intended to sell you those 2 lots. That's not part of the deal. So we had to work it out. But that's how this happened. When we ultimately closed with this survey, those lots are no longer in bold, and they're no longer a part of the legal description.
So
This was an earlier draft that was, when we first were negotiating the deal, this was an early draft that some broker found in the seller's records and faxed it to us and said, this is what the deal is. So we said, cool. So we copied that legal description into the sales contract. Seller signed it. Seller didn't even think about the fact, seller used to own all this land over here.
Okay.
And it sold it off piece by piece, but still had these 2 lots.
Right. So
And
that was
but
part of
intended
the-
to keep them, but intended to keep them.
So it was part of the original, when you platted it, it was part of the original,
Well,
all of it, and then
It's a part of his original, not when he platted it. This was platted back in
Okay, right,
1925 by 2 generations ago.
Okay.
But the point was, when the seller originally acquired the parcel, yes, seller had a bigger parcel.
And so he was selling pieces by piece, and he kept a certain, and that's why it came out like that.
But intended to save those 2 lots because those were vacant residential lots. And as it turned out, history-wise, we found out that twice the seller had tried to get the county commission to let them build parking over there too. The neighbors on both sides raised so much hell,
Right.
they couldn't build parking there. So it stayed vacant, but it stayed as part of their ownership. And we thought it was going to be cool, we put more parking in over there. But we then found out likewise, it wasn't really going to do us any good because we'd never get to use it for parking anyway, they'd already been shot down trying that.
Right.
So my clients decided, all right, what the hell, let's be friends, let's make a deal rather than fight.
So the seller had to go back and like what?
We just amended the contract to remove those 2 lots, that's all.
Okay, so did he have to like record something as far as on his deed?
No. Seller just sold us what you see there. I'm sorry. The seller sold us what you see here. The seller sold us a deed of all of this,
Excluding
except
that?
6 and 7.
Okay, okay.
Didn't. So when you see in the description up here, the second together with lots 6, 7, 37, 38, it just didn't say 6 and 7.
Okay.
It was 37, 38.
So in the sale, that's when you sort of separated the
Yep.
6 and 7 from everything else, in the
Exactly.
sale itself?
Yeah, so they figured that out.
Plain old, didn't include it in the deal, but we didn't require platting or replatting or anything, it could be just plain old, he owned 12 lots and he sold us 10 of them,
Cool.
you know, something like that.
Oh, okay, it just required a change in. the
Anything else?
actual survey drawing.
All righty. Huh? Okay. Roaring right along. Okay, folks, next chapter is chapter 17. No, that was 17. Excuse me. That was legal descriptions. Next chapter is chapter 18. And I'm trying to remember whether the author had a buzzword for this too.